Good evening, and thank you for all joining us. This Thursday, July 20th, 2017. My name is Kim Christian, and I'm a partner at Russo Law Group, PC. I will be hosting tonight's webinar entitled, How Decisions Are Made, Guardianships. Also joining us tonight is Eric Einhart, an associate at Russo Law Group who focuses in the area of guardianships, and Ellen Tolle, a registered nurse and care consultant on our team. Ellen's expertise is in dementia care. Ellen will be discussing how to get the most out of a doctor's appointment. Before we begin, I need to address a few administrative items. This presentation will last approximately 1 hour. During this time, I am sure you'll have questions. You can type your questions at any time using the question pod located in the lower right-hand corner of your screen. We will try to address these questions as we go along, but we'll also leave time at the end of the program for Q&A. No question is unimportant, and we will answer as many questions as time permits. Please note that we will be discussing financial and legal matters, and this program is not a substitute for obtaining professional, financial, and legal counsel. At the end of this presentation, you will see my contact information. Please contact me with any questions related to the material covered tonight, or any other questions you may have. Finally, after the presentation ends, you will see a survey. Please take a few minutes to answer the survey questions. Your feedback will help us develop and improve future webinars. Thank you again for joining us. Today's topic is how decisions are made, guardianships. What we'll cover tonight is how are decisions made from an individual who needs help? Who has the right to make those decisions for you? We'll talk about financial decision-making, healthcare decision-making, and guardianships. When does the need usually arise, and how does it come about? I'm going to talk about a few examples that might resonate with certain people that are listening, or just examples that come up that we see. Sally, age 78. She has Alzheimer's, and her daughter is concerned about her mother's well-being. Or Leo, age 45. He was in a coma for 30 days due to a car accident. Frances, age 12, has a developmental disability and lives with her parents. Dan, age 44, he lives in a group home. All of these are examples of some of the situations we may see where this need may arise. How will your finances be taken care of? Well, the first document I consider one of the foundation documents that everybody should have is something called a durable power of attorney. A durable power of attorney is for financial decision-making. It takes no power away from you, but it gives others that you choose the ability to make those decisions for you should you need them to. It's about financial decision-making, management of assets, and income. These can include your bank accounts. These can include your brokerage account, your real estate, your pension, any matters concerning financial decision-making. You want to make sure that you pick a person that you trust to be able to make those decisions for you in the event you require them to. Who has the right to make healthcare decisions for you? Well, you always have the right to make your own decisions. But the question then becomes, if you can't make your own decision, who would you want to be making those decisions for you? A healthcare proxy designates an agent to make healthcare decisions for you. You would nominate an individual that you trust to carry out your healthcare wishes. They are wishes pertaining to speaking to your doctor, about a surgery, about medications you should take, about reviewing your healthcare prognosis, all the way to end-of-life decisions. So it's very important that you choose someone that you trust to make sure that they will adhere to your wishes. You should also name successor agents if you can. A successor agent is an agent that you pick as a backup to your primary agent. For example, if you pick an individual to be your primary agent and one day they're not able to assist you, you want to make sure, if you can, to put a backup or multiple backups so that they can step in and assist you as well. Within the healthcare proxy, you have the ability to designate whether you'd like to donate your organs or whether you should choose not to, or if there's a specific organ or organs that you'd like to donate, there is a section in there so that your wishes may be carried out. In addition, it's very important that you specifically reference artificial nutrition and hydration. This is a very important part of the healthcare proxy to make sure that the wishes concerning artificial nutrition and hydration are carried out. So a healthcare proxy is very important. That nominates the individual or individuals that are going to make healthcare decisions for you in the event you can't make decisions yourself. Who has the right to make life-sustaining treatment decisions? Well, you have the right to make your own decisions, but you should also complete a living will if you want to set forth your instructions as to withdrawal or withholding of extraordinary life-sustaining treatments. You can choose to have triggering events in there, such as if you're in a permanent persistent vegetative state and perhaps two doctors agree that there's no chance of recovery, then you can put forth that you would not like to be kept alive by extraordinary life-sustaining treatment. This document is a document that's very personal to you and reflects your personal beliefs. So if you put that in writing, your healthcare proxy is able to take direction from this document and make sure that your end-of-life decisions are carried out. Another component of this document is the ability to put in that you would like pain relief medication. In many instances, that's important to our clients, and they'd like to put that in writing to make sure that their agent is clear about what their wish and direction is. So these are all documents that I spoke about that you can prepare in advance. That's why they're called advance directives. So it's very important to consider doing pre-planning to make sure your power of attorney, which is for financial decisions, is in place. Your healthcare proxy, which is for healthcare decisions, to make sure they're in place in advance. And your living will, which is about end-of-life decision-making. If you put these documents in place in advance, then you can have some peace of mind knowing that your wishes will be carried out. But what happens if you don't have these advance directives? And we're fortunate enough tonight to have Eric Einhart, an attorney in our office with us, whose primary area of practice is guardianship. So Eric, correct me if I'm wrong, but no one has the legal right to make financial decisions and personal decisions for you if you don't have those advance directives.
You're correct. If you do not have those advance directives, then you could be in a situation that is very difficult. It's not an enviable position to be in if you do not have the legal capacity to make decisions for yourself and those documents are not in place, because no one has the legal right to make financial and personal decisions for you without those documents or without a court proceeding where a guardian is appointed.
Great. So if I don't have those legal documents in advance, then a court proceeding to appoint a legal guardian would be necessary.
Absolutely necessary.
Okay. So what's the purpose of a guardianship? And I understand that there's different kinds of guardianship. Article 81, Article 17A, and Article 17. What is the purpose of guardianship, and can you explain to us a little bit about what each one of those guardianship proceedings are?
Sure. So the purpose of a guardianship is when someone is in a situation where they do not have the legal capacity or they're physically unable to communicate their wishes, and they need someone to make those decisions for them. So for instance, if you're in a situation where no one has the legal authority to do the banking for you or to write a check or to pay a bill, and you need someone to do those things, it's kind of a practical problem to have, and it's a legal solution, and you have to go through the process of getting a guardian appointed. In New York, there are 3 types of guardianship proceedings: an Mental Hygiene Law, Article 81, a Surrogates Court Procedure Act, Article 17A, and a Surrogates Court Procedure Act, Article 17. The Article 81 is a guardianship proceeding that takes place in Supreme Court in New York State, and it's for an individual who once had capacity, but now, as a result of functional limitations, is in need of someone to help them handle their affairs, their personal affairs and their financial affairs. They break it down, the law breaks it down into a personal needs guardian and a property management guardian. So you could have two separate guardians for two separate areas of your life. Article 17A is the Surrogates Court Procedure Act law where you're in surrogates court now, not Supreme Court, for this type of guardianship. And this is for adults with developmental and or intellectual disabilities, or an adult who has suffered from a traumatic brain injury. And these are individuals who never have had the capacity to make legal decisions for them. And the surrogates court oversees this, and there's a lot of oversight involved, which in my opinion is a good thing. You want to make sure that these individuals are protected. Article 17 is, again, you're in the surrogates court, and this is for a minor. This is to appoint a guardian of either the person and or the property of a minor.
Okay, excellent. So guardianship proceedings. How do you become a guardian? I understand that there's a petition that has to be filed with the court, and the court will decide on the powers to be given to the guardian if a guardian is appointed. What is that process like, and what does it mean to petition the court to become a guardian?
So it's a very difficult process to go through financially, emotionally. It could cause a tremendous amount of stress in the family, but essentially the nuts and bolts of it is someone who believes that a guardian should be appointed. Doesn't necessarily have to be a family member. It could be a nursing facility or an interested party. They use the term interested party, and that's kind of broad. But an interested party puts forth a petition to the court stating that they believe an individual, they're called an alleged incapacitated person, is in need of a guardian. In the petition, they explain why they believe that, and they make possibly a suggestion as to who should be the guardian. But sometimes there's no suggestion because they don't know who should be the guardian of this individual. The court then will appoint what's known as a court evaluator, who is known as the eyes and ears of the court. The court evaluator will go out and investigate the circumstances. They will interview the alleged incapacitated person and anybody that's in their life that would know more about that individual and their circumstances. There would be a court hearing, and the court would need to determine, whether the person has the requisite level of cognition or functional limitations that would require a guardian, so if they have capacity. And number two, if it is determined that they are in need of a guardian, who should be appointed guardian? Oftentimes, some people will consent to a guardianship. At the hearing, they'll understand that, hey, I'm in a tough spot in my life, and I need someone to help me out with certain things. So there'll be what's known as a person in need of a guardian. It's called a PING. So then, once you go through this hearing, the court determines to the guardian that you are in need of a guardian, and they appoint a guardian. They'll issue an order, and that person, the guardian that's appointed, will be the guardian. The challenging aspect of a guardianship, in my mind, is the lack of control. You are in a situation where the judge has the ultimate decision to determine whether you are in need of a guardian and who's going to be appointed that guardian. It could be a complete stranger, someone you've never met before and would never have wanted to be in charge of your financial affairs and or personal needs.
So Eric, would it be fair to say then that doing an advance directive like a power of attorney or a healthcare proxy, if the person was able to at some point be perhaps a good idea?
Absolutely. It would be a tremendous help because it would potentially avoid the need to spend months in this process, to spend thousands of dollars in court fees and legal fees to go through this process, and also it would help avoid some unnecessary pain in the individual's life and in their family's life, and provide some sort of certainty that someone that you love and you care about and you trust is going to be in charge of your affairs, not a stranger.
And there are also some situations where an individual may not have ever had the capacity to carry out advanced directives. So, for example, a parent with a child with special needs. Can you walk us briefly through a parent who wanted to become the legal guardian of a child who has turned 18 and what that is like?
Sure. Again, that's the Circuits Court Procedure Act, Article 17A, guardianship. And unfortunately, in that situation, there is not a possibility of a power of attorney or healthcare proxy or living will to be executed because they do not have the capacity to execute that. But the Circuits Court Procedure Act, Article 17A, is not as, in my opinion, as an intense a procedure as the Mental Hygiene Law, Article 81 proceeding. You've put forth a petition. It's usually the parents, the loving parents, who put forth a petition indicating that their child has certain developmental or intellectual disabilities that would require a guardianship proceeding. They would request that they be appointed guardian. They would provide notice to immediate family members. For instance, if there's an adult sibling of their child with developmental disabilities or intellectual disabilities, they would provide them notice. There is a court hearing that is not as involved as a Supreme Court proceeding. It's more of an understanding of what their limitations are. You'll need affidavits from an attending physician, such as a pediatrician and or a neurologist or a psychologist or a psychiatrist, that would be enclosed in the petition. So these medical affidavits are usually enough evidence that the judge will need to determine that there is an absolute need for a guardianship, and the people petitioning, so long as there's no objection, will be appointed as the guardian.
And at what age do you think it's appropriate for a parent to start this process?
You know, that's a really great question, because oftentimes I'll meet with parents who come a little bit too early. In my opinion, really 17 and a half, really, 17 to 6 months really is the time where you really want to get the ball rolling. I've had parents come in for children as young as 13 or 14.
Which is understandable.
Yeah, they're loving parents and they're thinking of the future and they're doing the right thing. But that's a little too premature. You want to wait till you're about 17 and that your child's about 17 and a half, 17. And
why 17?
Because 18 is the age of majority, and that's the age when, regardless of your child's ability, the law says you're 18, boom, you're an adult, and you have no one else can make decisions for you except you or a legally appointed guardian.
Great. So what are some of the benefits of becoming one's guardian? What can you do or petition to do to help your loved one? So
if you're going to be a guardian and you're requesting to be a guardian, you have to take stock of your life, I think, and determine that this is a role that you're ready, willing, and able to take, because it is not an easy role to be in. You have to really want to care for someone, and most people who are guardians are appropriately appointed. But there are many benefits of having a guardian, and oftentimes it's not just a matter of benefits, it's a necessity. There's protection of assets from loss or waste. You can access money to make necessary expenditures like taxes, property taxes, income taxes that need to be paid, investments of the assets according to a prudent investment plan, and very importantly, Medicaid planning and special needs trusts. That's a big benefit of having a guardianship.
Right. That will allow you to access benefits on behalf of the individual's special needs to assist them with quality of life protection. Other benefits of guardianship include the ability to sell their residence, medical and dental treatment decision-making, to arrange their living arrangements, healthcare decisions, tax and estate planning, and creation of living trusts. You can petition to become one's guardian over the property or over the person, and guardian of one's property would fall under the financial category. So tell us a little bit about that.
Well, the ultimate authority is up to the judge, but a guardian may be given a broad range of financial decisions. So they can collect and invest the person's assets. They can expend their assets and income on any of the person's needs. They can sell the person's residence if necessary or appropriate. They can protect the person's assets in a way that would maximize their government benefits, such as SSI or Medicaid. And they can make gifts of the person's assets to his or her loved ones when appropriate.
And what about guardianship of the person, the personal needs?
There's also a lot of benefits to that. A guardian can make important personal decisions for the incapacitated person regarding everything from routine to major medical and dental treatment. They can determine their living arrangements, their social interactions, their education and training opportunities, and they can apply for government benefits such as SSI and Medicaid.
All right, thank you, Eric. That was very informative on the guardianship process. And we are now going to transition to our spotlight speaker. Her name is Ellen Tolle, as I mentioned earlier. She is a registered nurse and care consultant. Ellen's expertise is in dementia care. And Ellen is good enough to join us tonight to discuss how to get the most out of a doctor's appointment. We feel this is a very appropriate part of this webinar this evening because part of being a guardian or part of being someone's healthcare proxy or power of attorney is making sure that you represent them in the best way possible, including dealing with their doctors and care appointments. So Ellen, I'm going to turn it over to you and ask the basic question or the broad question, and then we'll drill down. But how do you get the most out of a doctor's appointment?
Well, I don't have to tell you. I think we've all had situations where we've gone to the doctor. We thought we were really prepared. We get in there. We sit in the waiting room. We get called into the examination room. We wait and we wait. The doctor comes in. He does his exam. He tells you a few things, and he or she is out the door. And you're left going, oh, I forgot to ask this, or I needed information about that. And at that point, you're not going to get the doctor back in to answer these questions. So my philosophy is go prepared so that you get the most out of your visit by going in, knowing what you want to do, and having the questions or information that you need prepared for you. So my suggestions would be, before going to the doctor, whether it's for yourself or you're going with a family member who needs you there with them, is to, one, write down any questions or information that you may have for the doctor. It might be information about medication. It might be information about diet, maybe physical therapy, or a referral to another doctor and you're not sure who to go and see. So write down the questions in advance so that you have it there. Also, it's important to bring a pad and pencil with you. So when the doctor is speaking, you can write down the information. And don't be afraid if the doctor is speaking too quickly or uses terminology that you don't understand, to stop the doctor and say, can you repeat that? Or I didn't quite understand what you just said. Can you phrase it differently for me? You know, we are there to get the information for ourselves or for our loved one, so we have to make sure that we're getting all the information we need. So bring a pad and pencil.
I'm just going to jump in there because I was thinking in my mind to ask you and you answered it, but, you know, there's somewhat of for lack of better words, an intimidation factor. You know, there's a trained physician there and they're giving you information and perhaps it's in terms that you may or may not understand. So if I heard you correctly, it's okay to slow it down and say, you know, could you repeat that? Or perhaps I don't understand it. Is there a different way?
Exactly, because remember, the doctor has their schedule to keep, and I'm not getting down on doctors for that, but they have their schedule to keep. But when you're in there, you're number one. You want the information that you need, and you want your questions answered. So, you let the doctor know that you have questions or information that you want to review with them and that you would like to do it before they leave to see another patient. This way you're putting them on notice that you came prepared for the appointment. It doesn't matter if the doctor is happy about it or not. This is your appointment time, all right? And they are getting paid to see you, and you deserve to have every question or any information that you have answered and addressed by the physician that you're seeing. So the next thing is that I think is really important is to bring a list of updated medications with you. If it's for yourself, bring it for you. If it's for a family member, bring their medications. It's always good to have a list of medications along with the dosage and the frequency and which doctor ordered it, because a lot of people see more than one physician. And it would be wonderful if the doctors let each other know new medications that they've ordered or medications that they've discontinued on somebody. But we can't take for granted that that's going to happen. So the onus is on us when we go to a doctor to bring this information. And if you have it on a sheet of paper, you can give it to the person at the desk and ask them to make a copy. And then when you're in the doctor's examining room, since a lot of them use computers now, they can just take that sheet and put it right into the computer. So this is really important to bring that updated list of medications with you. Another really important thing is if you're going for yourself and you're going for something specific, not just for a regular general yearly exam, you might want to bring somebody with you. They don't necessarily have to come in while the doctor's examining you, but when you're talking to the doctor as far as getting information and having questions answered, sometimes it's nice to have an extra pair of ears listening to what's going on, so that if you think you caught something, but when you leave you go, maybe I didn't understand that, the other person might be able to help you and shed a little more light on it. Another thing that's really important when you're making an appointment, especially if you're making an appointment for somebody that has some type of dementia or some other illness where they're not going to be able to sit in a waiting room for a long period of time, which happens at some doctor's offices. You might want to talk to the receptionist when you're making an appointment, and if you can get out early in the morning for an appointment, if that works for you, then to ask for the first appointment of the day, and if not, to ask if you can have an appointment right after the lunch break, because a lot of doctors' offices close for a lunch break, and to have that first appointment so that you're not sitting with your relative for a long period of time, especially with people who have dementia. If they have to sit in a waiting room for an hour and a half before they see the doctor, it's not going to be a really good visit in the doctor's office because they're going to be getting very anxious and agitated. So that would be a recommendation that I would strongly suggest that you do. Also, if the person visiting the doctor has some type of dementia and might be upset by something that the caregiver wants to discuss with the doctor, and you can't discuss it in front of the person, you might want to write it down, just sort of like bullet points, and hand it to the doctor when they walk in the room so that they look at the questions and they can address the situation without you discussing it in front of the person who has dementia. Or, if possible, in advance, call the office and ask if there's a time that the doctor could talk to you prior to the appointment. Sometimes that's really difficult and you're not going to really have that time. So I always recommend bringing this information with you. Now, when you're at the doctor's visit, it's really important to make sure that if you're going with someone to the doctor and you're in the examining room with them, and I find that this happens a lot of times with seniors, maybe their adult child is going with them to the doctor's office to be an extra pair of ears, and they're in the doctor's office with them. For some reason, the doctor sort of gravitates to talk to this adult child instead of addressing the person who is the patient. And sometimes it's up to us to say to the doctor, can you please talk to my mom, or can you please, address your information to my dad? I can hear what you're saying. Because you don't want your relative to feel insignificant and disrespected in the doctor's office. So you sometimes have to remind the doctor to speak directly to them. And remember, there are no stupid questions, all right? Anything you ask is important because obviously you're asking the question because you're not really sure of the information. So always, you know, be assertive and just say, excuse me, I have a question, I don't quite understand this. And write everything down on your pad that you brought, your pen and, you know, and your pad. Write down everything on it. And again, before you leave the doctor's examining room, review all the instructions for clarity. Make sure that you understand everything so that you can ask any last-minute questions you have, especially when it comes to medications. Write down everything.
Excellent, excellent pointers and excellent explanation. So what I'd like to do now is open this webinar up to questions. There is a place where you can type in your questions, and we are more than happy, myself, Eric, or Ellen, to answer any questions that you have at this time. Okay, I think I see. Okay, so I see a question here, and is, why isn't a power of attorney enough rather than a guardianship? And that's an excellent question. And a power of attorney may be enough, actually. A power of attorney is an advance directive, and in most situations, if an individual executes a power of attorney in advance of the need because of some incapacitating event, then a guardianship actually is not necessary. So primarily, the guardianship petitions that we were talking about were referring to individuals that did not do their power of attorney in advance, or individuals who couldn't have done their power of attorney in advance. So why isn't a power of attorney enough rather than a guardianship? In most instances, it absolutely is enough to cover financial decision making. And then, of course, you want to execute a healthcare proxy to make sure that your healthcare decisions are covered as well.
I don't know if I just jump in. So
sure.
There's only really two instances when a power of attorney is not enough in healthcare proxy, and they don't come up too often. They do come up every once in a while, but really it's when you want to move somebody who does not want to be moved, or you want to limit their social interactions. So example would be relative does not want to go, want to be moved from their home, and they're putting up a fight. You cannot physically move someone without a court order. So a power of attorney would not cover that. It's really against the law. And you cannot limit someone's social interaction. So if you want to not have a relative see a particular person or be involved in a particular group, you cannot force their social interactions. A court order will allow you that, and the guardianship would allow you to do that, but not a power of attorney or a healthcare proxy in those situations. So I think that's important to be clear about.
Correct.
But in most cases, a durable power of attorney, if drafted properly by an experienced elder law attorney, should be enough.
Additional questions? Okay. Should you have an additional question that you didn't have a chance to ask, please email us at info@vjrussolaw.com. Thank you for participating in this webinar. Again, if you have additional questions, please email them to info@vjrussolaw.com. We have some really great seminars and webinars coming up. You can view the schedule on our website, which is www.vjrussolaw.com. I'd like to thank Eric Einhardt and Ellen Tolle for joining me today. And also, as a reminder, please take a minute to fill out the survey that will pop up after the webinar has ended, and your feedback is very helpful to us. Thanks again, and have a great night.